Hello, everyone. Welcome to the first episode of Immigration Fridays in 2025. I'm your host, Prashanti Reddy, and I'm here again to explore the ever evolving landscape of US immigration and the things going on in 2025 under the Trump administration. The week's journey has been a roller coaster ride, so fasten your seatbelts. What are we going to be talking about this week? This week, we will discuss what to expect if your H1B is coming up for renewal in 2025. The question is whether it will be more difficult or less difficult for employers and beneficiaries to file their H1B extensions in 2025. So let's first discuss the impact of the new H1B regulation that is going to be taking place or implemented shortly. The new H1B regulation talks about redefining what a specialty occupation is. It says that a particular position is a specialty occupation even if the position requires a bachelor's degree not in one single field but in several different majors as long as those majors are connected to the job. So you have to show a clear correlation between the major and your job description. CAP exempt criteria has been expanded and revised, and more companies, more nonprofits and governmental research organizations now qualify as CAP exempt organizations. Number 3, F1 student flexibility. Now the rule introduces a provision to provide greater flexibility for F1 students, especially transitioning from an F1 to H1. This is done by extending the cap gap period. The cap gap period previously expired on September 29th of that particular year. Now they've extended it until April of the next year. So even if it takes a long time for you to get your H1, you still remain in cap gap status. You don't have to do anything in the interim to remain in F1 status. Last but not the least is the program integrity measures that they've introduced. They have introduced enhanced oversight mechanisms to ensure compliance and prevent misuse of the H1B program. One of the things that they have reintroduced is the bona fide job offer requirement. So now you have to show that the employer has to show that there is evidence of availability of work. So the employer must submit documents such as contracts, work orders, project assignments, or just show that they have enough volume of business to require another employer. Now this was always there in the past, but in 2020 with the IT Serve versus Cessna court decision, they did not ask for that information over the last 4 years. They've made FDNS visits compulsory. FDNS visits are those visits conducted by officers after the approval of a H1 in order to make sure that you're compliant with all the H1B requirements. Previously, it was not compulsory to allow the FDNS visit officer into your office or into your home if you're working remotely from home, but now it's compulsory. If you don't, then on that basis they can revoke the already approved. Now let's talk a little bit about the impact of Trump's coming into power on the new H1B regulations. What is the new administration going to do with the new H1B regulations that were introduced by the Biden administration? So number one, they could potentially reverse or amend the regulation. This, of course, will take time because for any regulation to be amended or to be removed and replaced can take about 7 or 8 months or even up to a year because there is a publication period, a comment period, and then a final publication notification. So they may review and potentially reverse or amend any part of the H1B regulation, or they can reverse, most of it if they want to. And this could lead to changes in eligibility criteria, in the definition of specialty occupation, in the application process, or with reference to compliance requirements. They can also increase the scrutiny and enforcement, which is what they plan to do. They may heighten scrutiny on H1B applications to ensure compliance, and this could lead to increase in denial rates when you're filing for extensions. It could also lead to an increase in RFEs because they can ask questions and ask for documentation that they did not ask for under the Biden administration. There's also an emphasis on protecting the US worker. There could be, and it seems most likely that they will be, based on the previous Trump administration, what they did. So the policies may introduce a US worker first kind of policy. So that could include measures such as higher wage requirements or additional labor market tests. The higher wage rule was already introduced last time under the Trump administration, where the wages, for example, a software engineer would be close to $200,000, that would be the minimum wage. So anyone who was getting paid less than that would not be able to file a H1B petition. Thankfully, last time that rule was overthrown by a court, but that was overthrown for technical reasons, so it could be reintroduced this time, and let's see how it fares in the court moving forward if it's reintroduced. They can also, as I said, ask for more labor market tests, so maybe they could ask to see if there is actually a shortage for your particular job, so they can ask you to place advertisements in a newspaper, and if you don't get any applicants, then they can allow you to file the H1. Otherwise, they might say that you can't file the H1. The same way that presently the rules exist for filing a PERM for a green card, employment-based green card. What could the impact of this be on employers and applicants? For employers, that is companies that rely on H1B workers, they may face increased administrative burdens, potential delays in the hiring process, and uncertainty regarding the availability of skilled foreign labor. So they'll have to most probably look for their labor elsewhere. The applicants, on the other hand, may encounter more stringent eligibility criteria, so maybe some applicants will no longer qualify for their H1B extension even though they filed the H1 successfully the first time. They can be looking at potentially longer processing times and definitely a whole lot of increased uncertainty regarding whether their petition will get approved or not. Let's look into how you can prepare for something like this. How do you prepare? Firstly, it's very important, stay informed. Regularly monitor USCIS communications. Make sure you're updated with all the changes. Consult a legal expert. Seek advice from an immigration attorney to navigate this ever-changing landscape of U.S. immigration laws. More so now, ever-changing than before, because we expect a lot of changes and things happening constantly. So keep yourself abreast. The best way to do that is to contact your immigration attorney. Always have a contingent plan. Have an alternative plan just in case your H1B extension doesn't get approved. What is the plan if you plan to leave? What do you plan to do after you leave? Where do you plan to go? Have a contingent job available in India, or perhaps file for a change of status to another status such as an F1. Look into the L1 application to see if you qualify for that. So always have a contingency plan so that if your H1B extension is becoming due this year, then for some reason if it doesn't get approved, make sure you have an alternative option available. So given the dynamic nature of the way things are changing with reference to immigration policy, it's crucial that both employers and applicants, as I said, remain vigilant and proactive with reference to their cases. But what can you do specifically if you're going to have a H1B extension, whether you're an employer or employee? What can you do now to prepare, especially if your extension is due in the next 6 months to the next year? Number one, make sure you have all your paperwork that you require. If you're a consulting company employer or employee, make sure you have your POs, your contracts, end client letters, vendor letters all ready. Make sure your job is a long-term job, that whatever at the client site, whatever your contract is, make sure it's at least for a year or more. Use a job title that is not ambiguous and is easily approved and recognizable by USCIS. Now, your internal job title might be something else, but if your job duties lead towards a job title such as a software engineer, project manager, IT manager, these are some of the often used job titles, and which USCIS usually does not ask for, send an RFE on specialty occupation. They know that these jobs are specialty occupation jobs. So use one of those job titles. Define your job carefully. Prepare a really good job description which clearly shows that a bachelor's in computer science is required for your job if it's an IT related job. Your educational requirements should be carefully specified. The end client should say that the position requires a bachelor's degree, say, in computer science, and not say bachelor's degree in computer science, engineering, physics, math, and a whole lot of other things. So make sure that it's well defined and to the point. Also, for an employer, make sure that you're compliant, perform your internal audits to remain in compliance. Make sure your public access files are in order. Make sure your I-9 files are in order. Perform your internal audit so that you know that each of your employees is getting paid the prevailing wage. They're working at the client site as per the LCA. Last but not the least, don't misrepresent or sugarcoat any facts. Give the facts as they are, and hopefully that will work in your favor. If you misrepresent the facts, then you'll get into trouble. So please don't do that. I think with that, it's a wrap for Immigration Fridays this week. As we all know, immigration laws and processes can be complex. If you need any legal advice with the new policy or what to expect for 2025, please reach out to my email prashanti@reddyesq.com, or you can call me at 212-354-1010. Thank you for listening. Please tune in next Friday. Bye-bye.